What if the trustee steals my money? That's a question people often ask right before they decide to set up an asset protection trust. And that's the main question we're going to answer in this video. Can I trust the trustee? Plus, we'll talk about why the trust documents need to give the trustee enough control to be able to protect you. Will the trustee run off with my money? We love that question for two reasons. One, because people only ask it if they're truly serious about setting up an asset protection trust. And two, because it's easy to answer. Hi, I'm the business guy. I'm the CEO of Asset Protection Planners and Lawyers Limited. Our company was formed in 1906. We have attorneys and consultants on staff who you can call and speak with, and we're the nation's largest asset protection consulting firm. In fact, I've set up more international asset protection trusts than anybody on the planet. And if you appreciate this information brought to you by somebody with experience, please click the like button below so YouTube promotes it. Thanks so much. And you can also click the subscribe button and notification bell if you haven't already, so when more videos come out like this, you'll be up to date right away. Now, when we set up an asset protection trust for you, we assign a trustee to oversee the trust. In addition, they can distribute and manage the trust assets after you die. Now, the what if the trustee runs off with my money question is just hypothetical, because in my 31 years in this business, it's never happened to any of our clients, and we have clients who have been doing business with us for over 30 years in a row. Moreover, when we set up an asset protection trust, our practice is to place an LLC inside of the trust, make you the manager and the signatory on the bank account. The trustee only steps in the event that your legal opponent would take your money and you need them to step in before the court takes it away from you. Plus, when they do, per the trust agreement and the trustee's professional obligations, as well as government oversight, they're unable to misappropriate funds for their own benefit. Plus, the regulators make trustees come up with a client protection plan. For example, the regulators require, if the law firm needs to step in to protect the client, multiple attorneys must sign for the transfer of funds, not just one. On top of that, what I really want to know when an expert makes a recommendation is, hey, what do you do for your own family? And I can say, as the CEO of the top offshore asset protection trust formation firm in the nation, I have an offshore trust myself, and our offshore law firm is the only signatory on my own bank account. I've had a personal relationship with our personnel there for over 26 years as of this video. In fact, our trustee law firm is likely the same trustee that will assign as your trustee should you have us set up an offshore asset protection trust for you. Plus, if you're not happy with a trustee, you can simply fire them and hire another. Now, trustees have a duty of loyalty to the beneficiaries of the trust. A trustee company that acts unfaithfully will lose its trustee license. Plus, personnel can also be held criminally liable, since stealing from an estate qualifies as embezzlement. Committing embezzlement can lead to a felony charge and jail time. Plus, there's nowhere to run, nowhere to hide if this hypothetical event that has never happened to any of our clients happens. On top of that, if you look at the Global Corruption Perceptions Index of the most trusted jurisdictions, New Zealand ties for number 1. And guess what Cook Islands is a part of, where we set up most of our offshore trusts? New Zealand. So we're talking about the most trusted jurisdiction in the world, with very strict regulatory oversight, with personnel with whom we've had a relationship for 26 years with a stellar track record. Another set of questions we get is this. Somebody orders a trust, then they call us and want to scrutinize the trust line by line, asking us why it says this and why it says that. Why does the trustee have control? Why don't I have control? Why does it say the trustee can make investment decisions, etc.? Well, if a court order ties your hands where you live, the trustee will still need to act in your best interest and manage your trust assets responsibly. So to best understand why the trust is written like it is, let's talk about how asset protection trusts work and why we write them like we do. Let's picture you calling us and having us setting up an asset protection trust for you. First, asset protection trusts are irrevocable. Why irrevocable? The primary reason people use irrevocable trust is to protect assets from lawsuits. Legal theory commonly allows the creditor to step into the shoes of the debtor. It allows the creditor to do what he or she could do. For example, let's say you're the settlor of a trust, and the trust allows you to freely change the beneficiary to anybody else. If so, a judge could allow the one who got a judgment against you to step into your shoes and change the beneficiary to himself or herself. If the trust allowed you as the settlor to independently spend trust assets on yourself, the creditor could step into your shoes and do the same. So that's why it's irrevocable, and that's why you need a third-party trustee that a judge cannot control. Plus, some people use irrevocable trusts to make sure that others carry out their wishes when they're no longer around. This is common in second marriage situations where a spouse wants to make sure that the children from the first marriage get at least some of the assets. Next, some people ask us, if it's revocable, does that mean I can never change it? Well, it's not quite like that, as there are often ways to make changes, but it depends on how the trust is drafted. But if the purpose is asset protection, the changes often require approval of a third party, such as your trustee. Now, most trusts for this purpose are discretionary trusts. Now, with most irrevocable trusts, the settlers or the beneficiaries may request that the trustee make certain changes. The trustee can generally do so if it does not put trust assets at risk. So to say it another way, if you could change it directly, the judge could force you to change the beneficiary to your legal enemies. So by making it irrevocable, you're more likely to get what you want, the use of the trust assets. By requiring third-party intervention, it ties the judge's hands from directly forcing you to make changes against your will. For example, if you decide to cut out a beneficiary or add a new one, simply ask the trustee. The trustee at its discretion can do so, and the trustee also has discretion to decide whether or not the act would be in the best interest of the trust and if doing so would put trust assets in harm's way. Here's an example. If you said Joe Blow sued me and got a judgment, make Joe Blow the beneficiary of the trust because the judge told me to, the trustee can clearly see that you're making this request under legal duress and not of your own free will, and will naturally not turn your assets over to your legal enemy. If, on the other hand, you have a new child or grandchild and want to add that person as a future trust beneficiary, that would be an easy and obvious change where the trustee would most surely cooperate. So that's the reason why our attorneys write the trust the way it is, because we want to make sure the trustee has the ability to act in your best interest and not in the interest of the people who want to take your money away from you. Asset protection trusts. Well, asset protection trusts are irrevocable trusts. Not all jurisdictions have asset protection trust law. That is, most places do not have laws where you as the settler can also be a beneficiary of the trust and at the same time enjoy asset protection. Moreover, most domestic trusts in the U.S. have been penetrated by results-oriented judges who cast the law aside and grab the assets any way they see fit. Since the U.S. trustee is under their jurisdiction, they simply order the local trustee, who has no legal choice but to comply. So that's why the case law has proven that an irrevocable offshore asset protection trust in jurisdictions such as the Cook Islands in the South Pacific, which is part of New Zealand, and Nevis down in the Caribbean, where in our case our international law firm can step in to protect you. And we have seen this effectively protect assets from lawsuits in every case in which we've employed it. For more information, you can call us at the number below and speak with one of our attorneys or consultants. Allowances for the unforeseen. Now, another reason our attorneys draft the trust the way they do is that the properly drafted trust allows for a wide range of future possibilities. For example, there are circumstances that would warrant a change of beneficiary or trustees. Perhaps mom and dad unexpectedly have another child. One child exhibits evidence of long-term substance abuse. One child has a tragic military accident while the parents are still living. You get Alzheimer's disease. The trustee dies. A well-drafted trust gives the trustee broad powers to be able to take care of you and address all of these circumstances and more. So how can it be irrevocable if I can really change it? Now notice the operative word I. Irrevocable does not necessarily mean nobody on the planet can change it. It doesn't mean that you cannot suggest a change to somebody else. It just means that certain people cannot independently, without outside cooperation, change it. And this is a good thing. Remember, if you could just change the beneficiary at whim, the judge could force your whim to be your enemy at law. Now, we all like control, but if the trust is written improperly and you have complete power to change the trust, then you will likely get creamed in the courtroom. At that point, the judge would be the only one who would really have the control, and that would likely not be a good thing for you. And that's because he'll force you to use that control and change the beneficiary to the person who sued you. And that will allow them to take all of the money held therein in order to satisfy the judgment. So to have real control, set up an irrevocable trust with an independent trustee, then you put yourself in control instead of the guy who's suing you. Now you can get more information on how they work, how they're used, and what they do by calling Asset Protection Planners at 1-954-400-1050 or by visiting assetprotectionplanners.com and filling out a free consultation form. Please click like, subscribe, and share this video. Thanks for watching and see you next time. This is The Business Guy.